Welcome to the Planning Board Roles and Responsibilities. I am Laura Spector-Morgan, and I'm here with my partner, Joe Driscoll, and we are from the Mitchell Municipal Group, and we're going to talk to you a little bit about where you can find laws and what the Planning Board does and about staying in your lane. Our firm was formed, just to give you a little bit of background, in 1995 by Walter Mitchell and Tim Bates, both of whom have retired by now. And we only represent towns and cities. We don't represent any private clients. So this is all we do all day, every day, and we love it. And that's where we come from. So I understand that people can put questions in the chat, and we will do our best to answer those questions as we are moving along. If we don't get to them, we will try to do them at the end if we have extra time. And otherwise, everyone can feel free to go ahead and email us with any questions you might have. It might take us a couple days to get back to you. We're extraordinarily busy for some reason right now, but we will do our best to respond to all of the questions we get. So, okay, with that, we're going to today's roadmap. We're going to talk about finding the law, where you can find it when you need to look it up outside of your red book. We're going to do a big flow chart of what the planning board looks like, and then sort of the three jobs the planning board has, because while the zoning board has very specific functions and the select board has very specific functions in the planning world, the planning board sort of roams all over the planning highway. You have planning functions, you have legislative functions, you have regulatory functions. Sometimes you even have enforcement functions. We're not really going to hit that today, but you get to do a little bit of everything. So planning board is sort of the all-encompassing body in the planning world. So the first thing we're going to talk about is where you can find the laws you're going to need to do your job.
All right, so Red Book, great thing to start off in. Statutes and bills that we have, and then they're available online at that link. And that link provides you all of them. So, obviously Google searches are good to kind of get you some background, zero things in. But begin with the statutes. They're voluminous. They cover a lot of the specifics about what you can do in terms of zoning enactment. And it's going to permeate through everything we're talking about, various regulations, et cetera. You can also search for bills at that other link to just sort of see what's happening, what's going on. And also, if you're doing this search and you need to know some background, because that comes into play quite frequently. How are things being interpreted? Why did the legislature do things? You can use the bill search function or the legislative history and work through that and just sort of see how things came about.
I love diving into the legislative history. Sometimes it is not at all helpful, but sometimes it's really fascinating to sort of go back and figure out why laws were changed the way they were. There's sort of a sweet spot for what you can find for legislative history online. It's really sort of 1986 to about 2 years ago. And then you can find everything you need online. You can get all of the committee information, the minutes from the hearings, everything is online. If it's older than that and you email archives, they are fabulous about just scanning in what they have and sending it to you. If it's a relatively small file, which before 1986, it will almost always be a very small file. If it's newer than 2 years ago, you may have to go over to the legislative office building to look at it because it hasn't made its way over to archives yet. But the legislative history is almost always really, really interesting when you have an interpretation question.
Of course, there are Supreme Court decisions. They're the ones interpreting any of these bills, any of these ordinances, et cetera, that towns and cities have adopted. So that's the link to the opinions. It's not the best place to search if you're coming at it from an open-ended search. I want to know about topic X. If you're doing that, the search function is really not that great. This is much better if you know exactly the cases you're looking for, timeframes, et cetera. So frankly, the hack is just Google it, see what kind of cases come up, and then go to the Supreme Court site to find those specifically. The Cornell Law School site does offer some information. Do not treat it as gospel, though. It can be, it may not be accurate, it may be outdated, but it is a good spot, to sort of begin the analysis and begin sort of the identification of the topics and subjects you're going through, and maybe the buzzwords, et cetera, and to get a little bit of background. But the inquiry can't end there. You have to then go to, New Hampshire laws or bills or, Supreme Court decisions here in order to be confident in what you're utilizing. NHMA puts out their legislative bulletins. They're in depth, they're accurate, they keep everybody apprised of what's going on. So that's definitely a positive place to begin. As I'm sure you've all experienced over the past few years, there have been changes to the legislation, concerning how land use boards operate and what they can do. So that's always a good resource. An additional resource is the land use planning and zoning from the New Hampshire practice series. Again, as it says, it was originally put together by Peter Laughlin. It's continually updated now. This is a treatise that is excellent to rely upon. Our Supreme Court relies upon it. They look to this to really help them identify things, answer questions that they may have. So it's absolutely something you should review and trust. NHMA's Town and City Online Searchable Index, that's good. Plenty of articles, good functioning service that allows you to find what you're looking for. And then, of course, there's calling your lawyers. A lot of times there's a hesitance to do that. It comes with a cost, obviously. Land use boards tend to have smaller budgets, but addressing issues up front and saying, okay, we have this question, whether it be, somebody's saying a board member should recuse, or, somebody's interpreting our ordinance in a way that we've never seen before. Bouncing that off your lawyer allows everybody sort of at the inception of everything to decide, okay, what legal, guidance do you actually need? It may be, oh, well, those are, that's not really a good argument. You guys just do it as you've always done it. Or it could be, all right, we need to work with you through this whole process. But doing it there, and as you can see as we move forward in the presentation, there's so much that goes on along in the planning process that, if there's issues along the way, create potential appeals or potential problems as you move forward. So getting that guidance up front, as opposed to, oops, there's a big mess, we need to clean it up now, a lot of times is actually much better money spent, much more efficient, much cheaper to get that up front, as opposed to, crossing your fingers and hoping that it works out. So.
All right, this next slide has a lot of information on it. We're going to do it sort of at the forest level, and then we'll get into the trees. So this is the map of the New Hampshire planning world, and thank you, Ben Frost, for doing this last year. We just are representing it this year. So everything in the zoning and planning world starts with your master plan. You can't have any zoning without a master plan. The only thing you really can have without a master plan is subdivision regulations, but we start with the master plan. There are two portions of a master plan you have to have. Everything else is optional. We're going to get to that. Once you have that, you can have zoning. And zoning is what the planning board's role in zoning is, that you write it, basically. And zoning can be as simple as setbacks and height limitations and lot coverage. It can get into innovative land use controls, including inclusionary zoning, phase development, impact fees. It probably these days needs to include workforce housing, accessory dwelling units, small wind energy systems, and commercial fisheries. And then there's other local land use issues, excavation regulations, building codes. This is something that is this year's hot topic issue, because as it turns out, not a lot of towns have properly adopted their building codes. There are telecommunication tower issues that you need to consider, because there's very strict requirements on what you can and cannot regulate through your zoning code, through your site plan review regulations. and what can only be regulated as a building permit. Over here, we have temporary development moratoriums. We're going to talk a little bit about these. These can be adopted for up to a year to allow you to do things like adopt a master plan, adopt a capital improvements program, possibly adopt a growth management ordinance, possibly adopt an impact fee ordinance. I have been practicing law for about 26 years now. I've seen this once. And it was recent. It wasn't an old time. It's not like I saw it back in the beginning of my career, which is when I saw most of the growth management ordinances. I saw this recently. Over here, this is sort of your bread and butter as your planning board, is your subdivision regulations and your site plan review regulations. You can have subdivision regulations without zoning. To have site plan review regulations, you have to have zoning. Subdivision is exactly what it talks about. It is cutting land up into smaller chunks. Site plan is what you're putting on that land. And you can't use subdivision to regulate what you put on the land, and you can't use site plan to regulate how you're cutting up the land. For either of these, you need to have not only the regulations, but also rules of procedure. And then down here, we've got our regulatory and our non-regulatory boards. These are things we're not really going to talk about today. And these are state land use laws and local land use implications. Again, these are things we're not really going to talk about today, but these are things that always come into play when we're talking about subdivisions and site plans. Question just popped up in the chat. What is the advantage of adopting a town building code versus just relying on the state building code? Could a town just have the town meeting vote to accept the state building code as the town building code? And Joe, this is something you've been working on with Chris. Do you want to handle this?
Yeah, so when we're talking about the building code under your ordinances, it's actually the issue has come up about enacting the state building code. So the state building code, says, the various manuals, everything that, adopts all the standards and requires all buildings to adhere to those within the state. The issue at the local level comes from an enforcement side of things. So yes, absolutely, local municipalities go ahead, adopt the state building code. The problem that's come about is the actual method to do that has been the thing people haven't observed correctly. The statutes are not the clearest, and there's about 3 of them involved that kind of build off of each other in a very circular way. So that's more the hurdle. It's not necessarily, local communities coming up with their own standards or something like that. The issue that has come up is the proper enactment of it, because you need to enact them within your community in order to enforce them locally. Absent some type of condition on a site plan or something saying it's going to adhere to all building codes, all federal, state, local requirements, that kind of thing. If it's just purely enforcement of the building code, it needs to be done correctly. And that's the issue that we're seeing, is that the enactment hasn't really occurred.
Okay, we are going to move on now to the 3 realms of the planning board. It almost sounds like we're going into hell, but I promise you we're not. First, the planning role. The master plan, as we mentioned, this is sort of the basis from which everything stems. So we're going to talk a lot about the master plan, but we're going to warn you in advance that your master plan doesn't have a lot of, any teeth. In fact, what the Supreme Court has said is that the master plan is a general guide to aid planning boards in making zoning decisions. But it is the board's recommendations for desirable development, and unlike an ordinance, cannot be directly applied. So, very important to remember that you should never, ever, ever deny anything on the basis that it does not comply with your master plan, because your master plan is an aspirational document, not a regulatory document. So if you look in the statute, you will see that there are 2 portions of the master plan that you have to adopt. You have to adopt a vision section and a land use section. Everything else is optional. And I have seen a vision section and a land use section consist of 2 pages. and I have seen them consist of 50 pages. It all depends on your town and what you want your master plan to be. Everything else in the master plan is optional. The statute identifies several sections you can include. And it doesn't say that you can include things outside of those sections. But again, because it's an aspirational document, there's really no reason why you couldn't go beyond those enumerated sections. And those sections include things like, let's run through them. Gonna require me to find them. Hang on, I'm sorry.
Well, yeah, just to sort of piggyback on that, there are two required sections. You can kind of expand other things, but really the purpose of this document as a whole is a mission vision statement. If anybody's worked in bigger organizations or something, there's constantly strategic planning, and that's in essence what this is really to do. It's to kind of paint a picture of the community, and then the board in its legislative function tries to move kind of within that plan. The faults come about when people really start looking at this as a true planning document, get very into the minutia and the detail, and then it has no teeth. So it's, we want to see these very specific X, Y, and Z. Well, this doesn't enable you to really do that. So that is done other ways. So a great document to have. It really helps you identify, understand your community, understand its needs, understand how you can move forward. But again, always think about it from that 30,000 foot view.
And what you'll often hear is things like, our master plan has a natural resources section that says we want to protect open space. And this puts 100 houses on 200 acres, and that's not preserving open space. That's true. Your master plan probably does have that section, but you also have in your zoning and your subdivision regulations a cluster housing ordinance, and that's what you're actually going to enforce. And if you don't like that, your master plan gives you the basis to amend your zoning ordinance, not a basis to deny that application. One of the questions that just popped up in the chat was, can the planning board make conditions of approval based on the master plan? And I guess my answer to that is the planning board can make conditions of approval based on your ordinances. So your conditions of approval have to tie back to your ordinances and making sure that your project will comply with your regulations. And so ideally that will be in harmony with your master plan. But if there's something in your master plan that's not in your subdivision regulations or your zoning ordinance, no, you couldn't place a condition of approval based solely on the master plan. Your master plan should be revised every 5 to 10 years because your community changes and grows along the way. Generally speaking, you will see that as you're doing the master plan, if you're working with a professional organization or your regional planning commission, the first thing you'll do is sort of send out a community survey. What's your favorite part about living in this town? What do you want to see in the future? Some towns will do it sort of on a rolling basis. They'll do one chapter each year, so it's always ongoing. Some towns will do an overhaul every 5 to 10 years. It really depends on the town, how long it's been, and what you're looking to do with your master plan. Now, the capital improvements program, equally aspirational, still no real teeth. The Supreme Court has described it as a management tool for budget purposes, nothing more, nothing less. The sole purpose and effect of the capital improvements program shall be to aid the mayor and the budget committee in their consideration of the annual budget. Other than its management tool capabilities, a CIP has no part to play in a review of subdivision applications presented to governmental authorities. So this is like the master plan, but with numbers associated with it. You are looking at a schedule of municipal capital improvements for the next 6 years. What do we need to do? What do we want to do? How much is it going to cost to do that? And a capital improvement is a major project that's going to be undertaken with public funds. So roads, sewers, water, schools, that sort of thing. You have to have a capital improvements plan if you want to adopt an impact fee ordinance or a growth control ordinance. And that makes sense, right? Because if you're going to have an impact fee ordinance, it's in place so that you can collect fees to upgrade your capital facilities. Well, if you don't have a plan for the capital facilities, you don't know what facilities you need and what you need to collect impact fees for. Likewise, if you're going to have a growth management ordinance that presumably is in place because you don't have the facilities to accommodate the growth, well, if you don't know what facilities you're going to need and how much they're going to cost, why are you limiting growth? So that makes a lot of sense. The capital improvements program is adopted by the planning board. That's sort of the default. Alternatively, town meeting can decide that capital improvements program is going to be adopted by what's called a CIP committee. And that can be made up of various governmental officials, including like a member of the select board, a member of the planning board, a member of the budget committee. And everyone works together to come up with what we think we're going to need and how much we think it's going to cost. Now, growth management ordinances and moratoria. So I haven't seen a growth management ordinance in years. They were all the rage in the early 2000s because, as you'll recall, we had just houses popping up everywhere and schools were being overrun. People were very concerned with how are we going to accommodate all of this new residency. They all sunsetted because they were all required to sunset. And really the world did not end, which was wonderful. And now we're in sort of a different phase, right? Now everyone's talking about how much we need housing, especially small, affordable housing. And while we're still hearing concerns about how we're going to accommodate all that, it's not in the let's stop the growth. It's in a how are we going to accommodate all that? So it's a different twist on the same conversation. So these are really not intended to stop the growth. They're intended to slow down the growth so that we can build up the facilities to accommodate the growth, be that roads, be that water and sewer, be that schools. And schools is really generally where you hear it. These have to be done in a very specific way. You have to have a study substantiating the need, and there has to be an annual review process. And they're appropriate only if there's a demonstrated need to regulate the timing of development based on the lack of capacity to accommodate growth. And this, you cannot, there's a lot of cases out there that talk about denials of specific applications. And the court will say, this is a backdoor way of trying to do a growth moratorium. So for example, you'll see a town deny something as scattered and premature. And the court will say, no, it's not scattered and premature. You're just trying to stop growth and you're doing it without going through the growth management tools provided by the statute. And that was something that came up in the case of Etlinger Homes versus Town of Derry. In that case, the town had denied a subdivision application as scattered and premature because the school couldn't accommodate the additional students. And what the court held was that the ability of schools to handle the additional capacity is an appropriate thing to consider when determining whether a subdivision is scattered and premature. But because the adequacy of school facilities does not constitute a danger to health, safety, or prosperity, and because in that case, the town knew the schools were need capacity, and it needed to proceed with formal growth control regulation, including the need to formulate a comprehensive plan, The action of denying the proposal on the grounds of prematurity, scattered and premature, was taken to control growth, and it exceeded the board's statutory authority. So we want to be very careful that if we're in a position where we know our public facilities cannot accommodate more growth, that we are actively taking steps to address that, either by building those facilities or formally adopting a growth management ordinance to address those problems, rather than trying to do this on an application by application basis. Because if we're doing it that way, we may be running into issues when those denials are challenged in court. Temporary moratoria, as I mentioned earlier, I've seen once. It was in the last 5 years, and they're really appropriate in very, very extreme circumstances that can only be for 1 year. The findings for why we have to do this have to be part of the ordinance that's adopted by town meeting. They can only be proposed by the planning board, and they are there to allow you to have that 1 year to adopt zoning, adopt a formal growth management ordinance, do what you need to do to address whatever the emergency situation is that you find yourself in, for needing to bring those capital facilities up to snuff. So, next, we're going to move on to the legislative role, and particularly the adoption of zoning ordinances.
Okay, so obviously the vast majority of New Hampshire is comprised of towns, so I kind of speak about it in that sort of context. But zoning ordinances, that legislative function, it begins with the planning board. The planning boards are the authors of the documents. They're the authors of the ordinances, okay? And that's a very important function. And obviously it can lead to issues of who's doing what, right? So you're the authors, you're putting those together. Then you have to go, as many of you are familiar with, you have to go into a public hearing on those things. At the same time, citizens on their own by petition can bring zoning ordinances forward. Planning boards do not change those. Do not. Nope, don't touch them. And there has to be, those are subject to the public hearing as well. And of course, if there are changes made at the public hearing, you have to have a second one. So we always recommend to our towns, when you're scheduling these, your public hearings, et cetera, ahead of town meeting, you really should be leaving yourself the opportunity for the second meeting. If you're making substantive changes and you don't have that public hearing, you can't move it forward to the ballot. In terms of who then looks to these and interprets them, as we show there, the ZBA is the interpreter of it. And then your select board is your enforcer of these things. So you are the legislative branch, right? You're the one coming up with the language, the bills, putting it forward, and then other aspects of government move forward with those. We do note there's certain types of amendments that require direct notice to property owners. That has to do with if you're changing zoning boundaries and it affects less than 100 properties, and you're changing lot size or uses, and those affect 100 properties. So just be aware of what the ramifications of any impacts are, so you can properly notify people. You are then also able to, under 674-21, enact innovative land use controls. This sort of adds another layer that you can put on it as a planning board. We think special exceptions, zoning board aspect, but the CUP allows the board to have additional criteria and additional standards that need to be met along the way to achieve various things. And it can be used to sort of create opportunities in certain arenas, but then, sort of restrict that and be able to have kind of more teeth in terms of what that's going to look like. When you're enacting your zoning ordinance, there's certain things you should be aware of if you're kind of starting from scratch. There are certain things that need to be included and certain things that can't be done. Interesting ones, you can't regulate amateur radio antennas. The statute's clear that if a property owner is taking off and landing their plane on their property, that is an accessory use and allowed, unless it's specifically regulated otherwise. More recently, we have that home-based healthcare is a use by right, and you can't mess with that. And in addition to that, the family or group and family or group care is an accessory use to a primary residential use. And then there's certain aspects of limiting parking. Things that you need to allow: workforce housing, ADUs. Okay, so those need to be parts of your ordinance. If we move forward, we then hit sort of another one of your tools, and those are the subdivision regulations. And as Laura discussed, that's chopping up the land, right? And that the land is the focus of these, and you have to stay clear on that. You don't want to start enacting things that should be done in your zoning ordinance or should be done in your site plan regulations. Procedurally, your town meeting is your legislative body is who authorizes these. Then the planning board creates them, alters them, and moves forward with them. These include issues of, road standards, drainage standards. You can have landscaping included, stormwater, wetlands issues. In here, you can, and this may feel like a little bit of a stray outside of what it is, but you can have, your cluster subdivisions included in this, because it is about chopping up the land and how that can be done. So you're discussing then yield plans, et cetera, that can all be laid out in here. We always do like to note in here that if you're talking about certain regulations, when it comes to sprinklers, you can't require that those be in 1 and 2 family houses. Outside of that, you can require it. There's a lot of question about that comes up along the way, especially more in your maybe your college towns, et cetera, that have a lot of people renting. But that's an issue. We do see the question come up for short-term rentals as well, but can't do it for those two.
And you see it a lot in your rural towns too. Your fire chiefs are understandably concerned about large houses that are out far away with long driveways and not having a water source necessarily nearby. But the legislature has spoken very clearly on this. No sprinklers can be required in single family or 2 family homes.
Bonds associated with improvements for subdivisions are controlled by the planning board. One of the changes that happened relatively recently that we like to flag for people, I know I've received this question several times via email, is that you can no longer require only a letter of credit or cash or passbook. You have to be open to various forms of surety for people to post those bonds. From our putting on our pure sort of lawyer hats and the horror stories that we will hear about, somebody rolls in with cash to one of our clients and says, here you go, here's my $50,000 or whatever to secure this. And then our client says, thank you for the big bag of money. And that's the end of the discussion. And that's not a good way to go at all. If you're going to accept cash, you can do that. You just need an agreement set out as to the terms of it, what's going to be accomplished, who's going to do what, how this is going to be returned. That all needs to be laid out. It's just not kind of handing this over and seeing what happens. So obviously cash is nice. It's a very secure form for this, but if you're going to do that, there needs to be an agreement in place at it to address it.
And Kathy, I just saw you raise your hand. If you have a question, if you just want to put it in the chat, we can address it that way. Unless that was an accident. Keep going, Joe.
Site plan regulations.
Site plan regulations. Okay, those are me. So site plan regulations. This comes up a lot, particularly with short-term rentals, and it's something everyone needs to hear. Site plan regulations can be applied to non-residential uses and multifamily uses. So non-residential, not commercial, non-residential, and multifamily meaning 3 or more units in one building. So if you have a short-term rental that is occurring in a single family home, you cannot require site plan review of it. And that's all we're going to talk about short-term rentals today, because we could spend an entire day talking about short-term rentals. But that's really important for people to understand. Just because someone is making money from it, the Supreme Court, our Supreme Court, addressing this very issue, has held that it is still a residential use. So no site plan review if it is in a single family home or a duplex. Once we get into 3 units or more, we can regulate the 3 units or more under site plan, but not the short-term rental itself. On the other hand, I often hear people say, well, we can't require site plan review of farms. That's not true. Agricultural uses are non-residential uses. And if it is a new farm or a substantial expansion of an existing farm, you can in fact require a site plan review of the farm. Now, there are certain limitations on what you can regulate, but farms are subject to site plan review. So those are general site plan review guardrails. Again, the legislative body has to authorize the planning board to engage in site plan review. And you cannot undertake site plan review unless you have a zoning ordinance, which again makes sense because site plan review has to do with the use of the property and zoning has to do with the use of the property. And so if you don't have zoning regulating the use of the property, you wouldn't have site plan review regulating the use of the property. The planning board's jurisdiction is limited to whatever is in your site plan review regulations and whatever is in your zoning ordinance. You can't be regulating things that are not specifically identified in either one of those. So if you have very short and succinct site plan review regulations that don't cover something like landscaping, you can't then be requiring certain landscaping things unless the applicant is offering that to you. If the applicant offers it to you, by all means, jump on it and accept it and make it a condition of approval, but understand that you cannot require it. Now, your regulations, your site plan review regulations, the statute is 674-43, and it gives you a whole 44. It gives you a whole list of things that you can include in your site plan review regulations. But the things we generally see: parking, landscaping, visual aesthetics, environmental impacts, neighborhood impacts. It's really important that your standards are objective. You don't want standards that are going to be subjective or vague, because people should be able to pick up your regulations, read them, and understand what is required and be able to come to you with a plan that they know checks your boxes and meets your requirements, so that you don't have regulations that say something like a number of trees that in the planning board's discretion offers a sufficient buffer to prevent unreasonable disturbance of the neighborhood, right? That is so vague because we've got the planning board's discretion. We've got what is a reasonable disturbance, what is the neighborhood. You want to have something that says, like, you are required to have a vegetative buffer that prevents sound from traveling beyond the property line, if that's what you want. But you need to understand what you are trying to regulate and how you want to regulate it so that people understand what they need to do to comply with your regulations. You can have bonds for things that you require in site plan review. And in fact, landscaping is one of those things that we almost always have bonds for, because if you're requiring that 20 arborvitaes be planted, you want those 20 arborvitaes to live at least the first 2 winters. So you take a bond to make sure. And if 3 of them die, that way you can replant them and make sure that your sound buffer, your visual buffer is going to actually work. Whereas on the subdivision side, generally speaking, the bonds we take are for public improvements. Again, road, sewer, water. Subdivision site plan regulations are adopted by the planning board. They do not have to go to town meeting. You have to have a public hearing. And then they can be amended by the planning board as well. So site plan regulations, subdivision regulations, much easier to change than zoning board regulations. All right, so that is our legislative function at the planning board. And now we're going to move into actually reviewing applications. And again, if anyone has any questions, feel free to pop them into the chat. Subdivision and site plan review. So preliminary review is something that I go back and forth on, but more and more I'm starting to think that it's really a good idea for boards to require some sort of preliminary review, because it's a good idea for both the applicant and the board to be in a room together with something resembling a sketch of what is going to happen on the property. For the board to be able to say, okay, you want to do X, Y, and Z on your property. Well, X is permitted and that's great. And what you're showing looks fine. Y requires a special exception. So you're going to need to either go get that before you come to us, because our rules require that you get your zoning approval first and then come to us. And Z is not a permitted use in the district, so you're going to need a variance. And before you spend $40,000 drawing up a site plan, you might want to go get your zoning relief first. Or, well, that looks like an interesting idea, but our site plan review regulations require that you not put that next to a residential use, and you're putting it next to a residential use. So let's talk about how we're going to deal with that. Preliminary consultation is entirely non-binding. There's no public hearing, there's no abutter notification. But I beg of you, do not say something like, oh, there's no way I'm ever going to approve that. Because no matter how non-binding it is, if you say that, they're going to ask you to recuse yourself from the final application, and you are going to have to recuse yourself from the final application. So do that. Can waivers be asked for during the preliminary meeting? They can be asked for, they cannot be granted because you don't have an actual application. So you can discuss waivers and whether those are waivers that the board might be inclined to grant, but they would be not binding. Now, design review is a little bit more detailed, right? We're not just talking about a sketch on a napkin. It's still non-binding. It's still not a public hearing, but the abutters are notified. And we talk a little bit more about engineering, a little more about what other options, and a little bit more of advice from the board. Once design review is done, and this is an interesting concept because most boards don't actually have like a, okay, scene, now we're done with design review. But once design review is done, you're vested for 12 months from any changes to the subdivision, site plan, zoning ordinance. And you can, 12 months from the end of design review, submit your application to the planning board under whatever the regulations are at the time that your design review ends. So as a board, I think it's a good idea when you're done with design review to sort of make that motion and say, okay, this is the end of design review. Your 12 months starts now. And it's not something we think about a lot because it's a very informal process, right? But this 12 months becomes very important, especially if it's one of these controversial projects that the abutters have come in and they're really, really worked up about it, and you know you're going to get a petition zoning amendment. Make that motion. Make it very clear when that 12 months starts so that you don't have to fight about it later. These are things that the legislative body can decide you have to do, or you can make them optional. Like I said, I think having one or the other is a good idea just to start that conversation with people. Otherwise, you're going to have people come in with fully engineered plans, dead set on what they want to do. And there's not going to be that opportunity to say, well, maybe this isn't a great idea for these reasons. You're still going to have those people. But if you have this opportunity, at least you've had the option to have that conversation ahead of time. Now, once you get a formal application, of course, you have to notify the abutters. You have to determine if it's a development of regional impact. And development of regional impact basically means, is it going to have impact outside of your town? And there are specific standards in the statute. If you have staff, they will generally make a recommendation for you. And regional impact is one of those things that the statute makes pretty clear that if it's a close call, err on the side of deciding there's regional impact. The only thing that does is basically it pushes you out another meeting because you have to notify the surrounding towns and the Regional Planning Commission and get their input and give them status as abutters. So always err on the side of doing it. Acceptance of an application as sufficiently complete. This is something I'm seeing more and more that boards are not fully understanding. So let's talk about what it means. Acceptance means you have enough information to take jurisdiction over an application. It doesn't mean just that someone has filled out the form and handed you an application. And it doesn't mean that you have everything you need to approve the application. It means that you have a plan and you have enough information to say, all right, we understand what's going to happen on this property, and we have enough information to ask the questions we need to ask. And acceptance is important because it triggers your 65-day clock. But if someone hands you an application, and I'm thinking of a very specific application right now, and one of you is on this seminar, and it doesn't have a plan showing you what's going to happen on the property, do not accept that application as complete. And if someone hands you a plan and it has everything except a traffic study, that application is complete, accepted as complete. And
Yeah,
that
we see.
starts your. Go ahead, Joe.
Yeah, we see honestly how boards treat acceptance varies completely across the map. I'll be with some of our clients, and honestly, they treat acceptance as basically granting the application. That they have everything they need, everything checks every box, every question's answered. And if it's not, they refuse to accept it. And that's not grounds to do that. And as Laura said, the flip side exists as well, where it's just you wrote your name on a piece of paper. That's not an application. We're not accepting that. So it is something that absolutely varies community to community, quite across a broad spectrum. But it's got to be something that you can hold as a board and intelligently ask the questions, intelligently review your regulations, make sure all the boxes are checked. That's when you're accepting it, not that every question under the sun has been answered, because that's not fair to the applicant at that point.
Right. So once you have a complete application, and Melissa, I see your question, we're going to get to that. Once you have a complete application, you open a public hearing, and the question is who gets to speak. Now, my advice is everybody gets to speak. Generally, the applicant speaks first, then we let the abutters speak, and then anyone else who's there, let them speak. It's not worth having a debate over you live 2 houses down and you can speak, you live 4 houses down and you can't. If they're there and they have an argument that they're impacted, let them speak. That doesn't mean they get to appeal. That doesn't mean they get to speak for an hour, but let them speak about what their rational concerns are about the application.
And on this part, we didn't really hit on it at all because obviously limited time, but we did mention it in the mapping. This is where your rules of procedure really come into play, right? Like this is where that's the document where you're really solidifying how your meeting's going to go and establishing the rules. And sticking with those is actually very helpful to boards. You're applying things uniformly to everyone. Again, we're trying to get the greatest amount of input as possible, making people feel heard. But if you're able to point to something that says, no, 3 minutes is the cap for everybody. And, it's in the chair's discretion that if people are just repeating things that they can move beyond that. Like that's a tool you can use to have a thing to look at when you're talking to people in a contentious application. Well, so and so got this much time, I didn't, those types of features. And it can help you address some of the contentious ones. I mean, we'll see it all the time where an applicant comes in, they have an idea, there's people very against, and then it turns into a conversation, a heated conversation between the two of them. And you're going to want the opportunity to be directing this through the board, and the board's the one asking questions and getting into that. So.
And the question is, what about non-residents? Well, I think with non-residents, it's going to be a judgment call, right? Sometimes you're non-residents in a butter. Sometimes it's an application of regional impact, and then you're going to want to let those non-residents speak. Sometimes they're people from 4 towns away that just don't like the Walmart moving into your town. And again, I think you should let them speak for the 3 minutes you would let anyone else speak. But I wouldn't go out of my way to let them have a platform that they can, stand on their soapbox and make their usual stump speech, whatever that might be. So I don't particularly think there's any benefit to treating non-residents differently from residents unless they're problematic, right? And this is true of anyone, if anyone stands up and is disruptive to your meeting, is causing trouble, is not speaking to the application, is not following your rules of procedure, those are people that you're going to need to deal with, and you're going to want to talk to your town council about how to deal with them. But those are people that are disrupting the meeting, and you can have them removed. Again, speak to your town council about how to handle that. Another question that came up is during application acceptance, this is where waivers are taken care of. Should each waiver be voted on separately? Absolutely. Each waiver has to be voted on separately, and it has to meet the waiver standards independently. And we talk about that a little bit, a few slides from now. I think we talk about it a few slides from now. Approval has to be made within 65 days, but it's 65 days-ish, right? If you get to the end of 65 days and you're still at the point where you're waiting on a stormwater report, a traffic study, you don't have all the information you need because it's a complicated application, right? I mean, sometimes it's a 2-lot subdivision. We can approve that in one night. Sometimes it's a 200-lot subdivision. We can't approve that in 65 days. That's okay. You say to the applicant, we're at day 63. We're going to need you to extend the 65-day deadline. If it is a reasonable applicant, they're going to say, of course. If it is an unreasonable applicant and they say no, your answer is, okay, then we don't have enough information to grant your application, and we're going to deny it without prejudice to your ability to come back and reapply when you have all the information you need. And that is a completely valid action for you to take. The statute says it's a completely valid action for you to take. And there is Judge Class. You will end up in front of Judge Class down in Manchester. And if truly you do not have enough information and you have asked for the information and the applicant has not gotten it to you, you are going to win that case every day of the week. Which brings us to just a slight comment on how appeals are handled in the state. Appeals of land use decisions will go to one of 2 places. They will go to the Housing Appeals Board, assuming we still have it, or the Land Use Court down in Manchester with Judge Class. And they are held almost always on the record, which means there are no witnesses. There are no exhibits. It is, as a general rule, a 30-minute argument based on the record. And the record is a binder that consists of every piece of paper that was in front of your board, including, and most importantly, in my opinion, the minutes. So it's really important that everything you do gets documented and that every reason you are using to grant or deny an application is found in that record. Yes, people can still post in the chat. So If an applicant had to reapply for any reason, do they need to pay the fees again? Yes, as a general rule, they do have to pay the fees again. The board can make the choice to waive them if they're asked to waive them. But honestly, if someone has been difficult and just refused to extend the 65 days and legitimately should have done that because they didn't give you the information you needed, I wouldn't waive the fees, but that's just me. Anyway, back to appeals. It's on the record. So it's really important that everything you do be found in that record. We want really good minutes. And some boards do verbatim minutes, and some boards do very, very, very minuscule minutes that just comply with the right to know law. So if you're doing that, that's fine. But please keep the tapes so that we can have transcripts made. Because that's all the judge is going to have to make his or her decision as to whether or not your decision was reasonable and lawful based on the record before you. Minutes in question, are they from the planning board or the zoning board or both? It depends. Right now we're talking about the planning board, so they would be the planning board's minutes, but sometimes the planning board decision gets appealed to the zoning board, and then that gets appealed to court, and so it would be both minutes that would be important. So once we have an approval, there's two different kinds of conditions. Conditions precedent. The approval isn't final until they're met. For example, you need to go get your AOT permit from DES. That is a condition precedent. That is something that has to be done before that plan can be signed, approved, and recorded, and you can take any action on it. The planning board enforces those conditions. Conditions subsequent. Ongoing conditions after the final approval. Hours of operation. You can operate from 7 in the morning to 11 at night. Select board enforces those conditions, or your building inspector, whoever the select board has delegated enforcement authority to. So I think those are all the questions, and I think that's all the notes I had. Oh, the only other note I had is that the legislature has very recently limited who gets to appeal for ever. It's been someone who is aggrieved. And the legislature has very recently limited that to someone who is an abutter. Um, uh, so it would be an abutter, a party to the action, or the select board are really the only entities that are able to appeal board decisions these days. So that is an interesting change that they have recently made. So now we're.
I think the note is worth pulling out too, that you can't refuse to accept or approve an application on the basis that state or federal permits have not been issued. You make those conditions of your approval, that they get the AOT permit or the shoreline permit, like that becomes a part of the whole picture, but you can't say, well, we don't have the AOT permit, so you're denied. You make a contingent on those, and then your approval is contingent upon that. If they never get that part of the approval, they don't have an approval. It goes away. So just keep that in mind. We see that from time to time where people are saying, well, they don't have what they need from the state, so they shouldn't even be in front of us. And that's not the case.
True. Waivers. I told you we'd get to waivers. So waivers are, they're like the variances of the planning board. So you can waive your subdivision regulations or your site plan regulations. You cannot waive the zoning ordinance. Question just popped up in the chat. If the planning board denies an application, can't the applicant appeal? Absolutely. If the planning board denies the application, the applicant can appeal. If the planning board grants the application, the abutters, the select board, or yeah, the abutters or the select board could appeal. Yes, so if the planning board denies the application, the applicant could appeal. The basis for granting waivers from your subdivision and site plan regulations is different than your basis for granting variances from the zoning ordinance, and it's easier. So again, you want to have your basis for the waivers recorded in the minutes. It's that whole record thing we were talking about. And you can grant a waiver if you find strict conformity would pose an unnecessary hardship to the applicant, and waiver would not be contrary to the spirit or intent of the regulations. And hardship here is not hardship arising from the land. which is what we see over in the zoning world. It is hardship to the applicant, and it includes financial hardship. Or specific circumstances relative to the site plan or conditions of the land in such site plan indicate the waiver will properly carry out the spirit and intent of the regulations. Now, this does not mean we like the other design better. There is a case out of the town of Stratford where the board had granted a waiver to allow a loop road in lieu of the kind of road that met the regulations. And what the court said was the abutters appealed, and the plaintiffs contend that there's no evidence that the loop road configuration would cause undue hardship or injustice to the developer, and therefore the board erred by waiving the regulations requirements. The court agreed. The board had no evidence before it that the loop road configuration would cause any hardship to the developer, much less undue hardship. The record reveals that the sole reason the board decided to waive the requirement was because it preferred the cul-de-sac design, not because the loop road design would cause undue hardship or injustice to the developer. So keep in mind that those standards, if challenged, really will be enforced.
And that comes back to what discussing earlier in terms of appeals, building your record. We need a good record. We need findings of fact, et cetera, for these waivers as well. As we saw from the question earlier, a lot of boards treat waivers sort of right out of the gate. Like we're going to deal with these right at the beginning. And it's, oh, you need these 5 waivers. Sure, we'll grant. Well, no, you need to establish each one. You need to have that clean in your record so that when it comes up on appeal, your lawyers do have what's necessary to substantiate your decision and explain that to the court.
A couple of questions in the chat. If a single family home community was required to have sprinklers when built 20 years ago, can a homeowner discontinue using a sprinkler system now that they're no longer required? My answer to that is I think any single family homeowner could decide to turn off their sprinkler system at any point. The requirement is that it be installed, right, Joe?
I would
I don't
think, yeah,
know.
I mean, that's kind of a use issue, but that's an odd one.
Yeah. And then, so I don't know, and I'm not going to incur the wrath of the fire chiefs to go any further than I've gone on that one. The other one is there an RSA timeframe that conditions precedent must be completed, or is it entirely up to the planning board to determine when an approval expires? We are going to get to that, hopefully, when we get to vesting, which is 2 slides from now. So, and we have 15 minutes. Off-site exactions. Joe, do you want to talk about this?
Oh, well, this is sort of we talked about at the beginning, the capital improvements program and getting an impact fee ordinance, out of that. It's required. For any of you who, heard that and all of a sudden said, oh my goodness, like, what does that mean? Like we can't get anything because we don't have that. Well, you are allowed under 674-21-5 offsite exactions. But this has got to be where the improvements are necessary for occupancy of any portion of the development, and it's limited to your roads, drainage, water, and sewer. Okay, it's not, we'd really like it. It'd be really nice if that road had 4 lanes instead of the 2 it has. It's not what preferences there are. It's that you can't occupy the property in this way without these upgrades. Let's see, you can't make a monetary exaction when the developer agrees to make the improvement. So, you need to upgrade this part of the water supply coming onto the property. Okay, I'll do it. All right, well, there you go. You can't double dip. You can't get both. You can't say, okay, we're going to charge you for it because we're going to do it while at the same time they're okay with doing it. Anything you want to add there?
Nope.
Let's see. And then, as we say here, you got 6 years if there's some partial funding by the municipality to refund it if it's not done. But again, these are about reasonability, restricted to the roads, restricted to drainage, water, sewer. And it's it's got to be a condition that's occupied by it. And it can't be sort of future looking either, right? Like, okay, well, our system can handle your 4 lot development here or something. And but there's land near you that could result in another one of these developments. So we want you to upgrade in case somebody wants to come in there. And it's not that either. It's got to be about this project and about how this project can be effectuated.
And the question that just came in, what about an impact on fire or other emergency services? You cannot use offsite exactions for that. You can use impact fees for that, but not offsite exactions. So then we come to vesting of development rights. So vesting has to do with protecting your plans from changes to regulations. And this has to do with you have to actually invest in your plan, right? So the planning board approval gives you 24 months for most local regulatory changes, as long as you have active and substantial development or building. You get automatically 24 months, you get another 3 years, and then as long as you are substantially completed, you are protected forever. Now, if you get your approval and you do nothing for 5 years, and there's no condition in there imposed by the board that says this expires after 3 years if you don't do anything, your approval is good forever. It never expires. After 5 years, it's going to be subject to any new regulations that are adopted. But if those regulations don't affect your plan, 20 years down the road, if it's still recorded at the registry and hasn't been revoked by the town, you can still build your plan. So vesting only has to do with protecting it from changes to regulations. It has nothing to do with whether or not it expires. That is something that is controlled by the planning board imposing that time limit on your plan. All right. And with that, we might actually be done talking. Does anyone have any more questions to pop into the chat?
I guess just quickly on the vesting piece, I mean that active and substantial development is a subjective thing, right? Like we can't sit here in this presentation and say if things 1, 2, and 3 occur, then therefore you have active and substantial. It's going to be case by case. You're going to be reviewing it, but if it walks like a duck, talks like a duck, it's a duck, right? Like if somebody it's a 20 lot subdivision. They put in a road. They built a few houses, but not all of them. Yes, it vested, but it runs the gamut. I mean, Laura gave the example of didn't touch it at all, but you'll see a lot of these, and I mean, you'll see them now. A lot of failed developments and whatnot have just a portion created, so you can be left with that judgment call.
One of the questions that just popped up is there a limit on the number of continuations an applicant can request? No, not in the statutes. I know some towns, for example, will, after 3 continuances where nothing sort of happened at the meeting. Well, let's stop and go back for those people who don't. Let's go back to the basics. You notice your public hearing, right? And then you can continue that public hearing to a time and date specific. And then sometimes you get to that time and date specific and the board chair says, oh, the developer has requested a continuance. We are going to continue them to our next meeting and then to our next meeting and then to our next meeting. And you can do that forever. But a lot of boards after say 3 or 4 will then go ahead and send like a courtesy not certified notice to the abutters to let them know it's still in the pipeline and nothing has happened. Or some boards will, after a certain amount of time, deny without prejudice and make them come in and reapply. So that might be something you want to put in your rules of procedure. Next question, how do you put an expiration date on an approval? You make it a condition of approval that this approval shall expire in 2 years if not substantially completed, but then you have to define substantial completion. And then clarify your comment that site plan for short-term rental is not allowed for 1 and 2 family residences. Okay, Site plan approval is not allowed for single family and two family residences. Site plan approval is permitted by the statute for non-residential and multifamily developments. So 3 or more units in a building and non-residential uses. The Supreme Court has held that short-term rentals are residential uses. So if you have a short-term rental taking place in a single family home, it is by statute not subject to site plan review. And I think if you are a town that is going to try to require site plan review for that short-term rental in that single family home, and the owner challenges it, I think you are going to lose, because a court is going to hold that by statute, you cannot subject that use to site plan review. I could be wrong, but I don't think I am. And Michael Scully would like to know if either of us have seen any good movies lately. Joe?
Well, I have 2 kids under 3, so anything sort of Disney related is kind of my only movie reference at this point. So.
And I think the last new movie I saw was Wicked, and it was fabulous. So I would highly recommend that. What if you have 3 rooms that you are using for short-term rentals in your house? I think it's still a residential use. And see, I knew we were going to go down this rabbit hole. That's why I said that was what we're going to talk about. I think it's still a residential use, and you cannot require site plan approval for it.
I mean, in that circumstance, maybe you start going down the road of like a boarding house if you have that defined in your ordinance. So now it's not in the short-term rental bucket, but that gets very specific to what you have on the books.
Yeah. And again, we could spend an entire day talking about short-term rentals. So it is the one thing in my life that I will say I wish the legislature would deal with. And then we wouldn't have to just sort of muddle through and figure it out. I too see a hand up from Eric. If you're not able to use the chat function, you can email your question to planning@livefree.nh.gov. Is the fire chief inspection of a potential short-term rental allowed? Yes, I believe it is. All right, if there's no more questions, Brendan, are you okay if we end 3 minutes early?
Yeah, we can certainly do that. Here, let me. I'm gonna take back control. Yeah, we can leave a little, or yeah, go to lunch a little on the early side. I've got a lunch break from now until 11:45. I'm just trying to see if that email might come in. So I'm hanging tight, but yeah, I don't see any additional questions from anybody at the moment. Yeah, thank you. Very helpful. I agree.
Thank you, Bill.
Yeah, well, thank you, Laura and Joe, so much for joining us, and yeah, yeah, really appreciate your time on this rainy Saturday.
Thank you,
Not a
everyone, for
problem.
joining us.
Yeah, it's been a pleasure. Thank you.
All right, and for everybody else, staying tuned. I'm gonna leave everything up and running. I'm gonna mute myself and take my camera down, but the session will stay open. But yeah, if everybody wants to, oh, we do have a question from Michael. What is your contact info? So that should be in the
Maybe on the first page.
Yeah, I believe it's on the first page.
Yeah, it's on the first page of the materials.
Oh, and actually, Eric's question did actually come in. Hang on, let me. If you guys want to stick around we got
Sure.
1 minute. 1 second. Here we go. Let's pop that into the chat. It's kind of a big one. Let's see. So I thought
I got it, Brendan.
Oh, you got it. Okay, we got it in there twice.
I don't know. This has to do with whether or not cities can require sprinklers on 3 to 4 units. I don't know.
Yeah, we'd have to look into that one.
Yeah, this is very specific fire code language.
Okay. All right. So perhaps talk to the fire chief. Yep. Okay.
When in doubt.
When in doubt. Excellent. All right. Well, yeah, it's 11:44, and yeah, well, 11:45. There we go. All right, it's time for break. I'll see everybody in about an hour. Again, thank you so much, Laura and Joe, and yeah, we'll see y'all soon.
Thank you, everyone.
Thank you.
Bye-bye.
Bye.